Namaskar, I'm Assistant Professor Kritika Dev from LJ School of Law, and today we'll be dealing with the group of sections which talks about burden of proof. Yeah, finally we have reached to that very topic, the burden of proof. Now let's move on to these sections directly. Now, before moving on with this very burden of proof, I would like to tell it to you that again, the topic burden of proof has been divided into two parts. Now, this is the first session, and you also have the part two, which will be dealt in the second session, right? So, it is important that you see both the parts in order to get the clear idea as to what burden of proof is. So, now the general rule states that he who asserts must prove, right? If I am there in the court and I want to prove something and I assert that very fact, then the burden of proof lies on me that I prove that very fact because I am asserting. If I am saying that B caused grievous hurt, of course, he caused that hurt to me. Then, if I assert that very fact, the burden of proof is on me in order to prove that B had caused that grievous hurt. Now, in order to support that very statement, there is a Latin maxim which has been given, e incumbit probatio qui dicit non qui negate, which simply means he who asserts must substantially prove that fact and not the person who denies it. Of course, the person who is denying it should not come for the denial first. Rather, the person who is asserting that very fact should prove that very fact. Now, this is the general rule. Now, let's see what this section says. The section here says, section 101, which says, whoever desires any court to give judgment as to any legal right or liability dependent on the existence of the facts which he asserts must prove that those facts exist, right? So if, as I said, if I want the court to believe in something which I assert, which I believe to exist, then I should prove that very fact before the honorable court because I am asserting that very fact, right? And when a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that very person, right? So here the burden of proof lies on the person who has asserted that very fact or who is asserting that very fact and who wants the court to believe on what he is asserting, right? With this, let's uh, move on to the again the extended version. Burden of proof on the person who alleges the affirmation of the issue. So here burden of proof is on the person who alleges that that issue exists. With this, let's move on to the next section. Now what the next section says, now you must have heard about burden of proof, but do you have any idea about onus of proof? Now, yes, this is the section which deals about onus of proof. Onus of proof, it shifts according to the situation, but burden of proof, it never shifts. So when it comes to, of course, this thing is known as burden of proof. So on whom burden of proof lies? The burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side, right? So here it shifts from party to party. If, for example, let's take an example. If I prove my point, I somewhere give the evidence that when the grievous hurt was caused, B was there and B caused the grievous hurt. Now B now has to give an evidence in order to prove himself as innocent. Now at this point of time, if B does not give any evidence, then he will lose the case. He would fail if no evidence at all were given. I have submitted my part. Now it is time for him to submit his portion and to give evidence related to what he is saying. So now at this point of time, if no evidence is being given, then B would lose. So it keeps on shifting, right? So that is given under section 102 of Indian Evidence Act. Now let's see, fixing burden of proof on the person who would fail if no evidence at all were given. So that is the overall guideline. That is the overall section, right? Just in this very box. Okay. Now let's see what section 103 of Indian Evidence Act states. Burden of proof as to particular fact. Now, the burden of proof as to any particular fact lies on that person who wishes the court to believe in existence, unless it is provided by any law that the proof of that fact shall lie on a particular person. Now, what happens under this section? Now, here let's take an example in order to understand this section properly. For say, there is a prosecution going on against B, like B has committed theft against A, of course, right? B has committed theft against A. Now, A would like the court to believe on the fact that B has confessed the very crime in front of C. Now, if A wants the court to believe in such a thing, then A has to come up with an evidence. Right now, the burden of proof lies on A because A wants the court to believe on a particular fact. Now, that particular fact is that B has confessed the same in front of C. Right? So, in order to make the court believe in this fact, the burden of proof lies on A because A knows this very fact and A wants the court to believe on this very fact. So here now, in order to prove this very confession, the burden of proof is on A because A says that A wishes the court to believe in its existence. So here it lies on A. With this, now standard of proof in what happens in civil and criminal cases. If we say section 103. Now, in a criminal case, the case has to be proved beyond any reasonable doubt. There should not be even a single scope where it could be realized that the accused might be an innocent person. It has to be proved beyond any reasonable doubt. But that is not the case when it comes to the civil cases. The court does not believe in this rule so strictly, and as it is a civil case, it should not be beyond every reasonable doubt, right? So that is the basic difference between when it comes to standard of proving in civil cases and in criminal cases. Now let's see what section 104 tries to say. Burden of proving fact to be proved to make evidence admissible. Now the burden of proving any fact necessary to be proved in order to enable any person to give evidence of any other fact is on the person who wishes to give such an evidence. Here, let's take that very simple example of the primary and secondary evidences. Now, here, if a person would like to give a secondary evidence, now before proving or before giving the secondary evidence, one must prove that why is he not giving the primary evidence. So, as I stated, the condition should be somewhere mentioned under section 65. So before giving the secondary evidence, the person has to give evidence as to why he is producing the secondary evidence and why not the primary evidence, right? I guess this is clear with this very example. Now, when we read section 105, there is a case law, burden of proving that case of accused comes within exception. Now, this is the case law, that is State of MP versus Rangaswamy, 1952. Now, in this case, what happened? He killed the other party. So, as I was saying, he was charged of murder by shooting the other party. Now, here, plea, of course, this was the charge framed and that was the fact and issue. Now, that person gave the plea or took the plea that it was raining that time. And of course, I was in a mood of shooting. So, I just thought that it is a hyena because the, the disease was covered with something which is of brown color, and I was under the impression, and it was raining and the distance was around it was around 152 feet, so I could just feel that that is in hyena, and under that impression I did shoot. So what? Because the burden of proving that he falls under the exception was on the accused, and he proved that very thing. He proved that it was out of accident. So he came under the general exception of it, that it was because of accident. And he wasn't expecting any man to be there. So when it comes to anything and the accused takes the plea that he comes within the exception, then the burden of proof lies on the person who wants to come under the general exception, right? Okay, with this we have the last section of this very session is burden of proving facts, especially within knowledge. So, when any fact is specially within the knowledge of any person, the burden of proving that fact is upon that very person. Now, here let's take a very simple example. If the facts of the case simply shows that the person had the intention, a simple intention of doing this very act, whatever may be the act. Now, if that person had carried some other intention or some other knowledge, now to prove that intention or knowledge, the burden of proof is on the person who says that I had that other special or different intention. The burden of proof will lie on that very person. So with this, I guess the whole burden of proving and section 101, section 102, 3, 4, 5 and 6, everything is clear till now. So as I said, this is just the part 1 of the session. Part 2 is there in the other session because it could not be covered in this one session. So I have made part 2 of the same. So kindly do watch it in order to get the clear and a complete idea as to what burden of proof is. Right? You will understand the complete fact when you will read law as a whole. Don't leave some parts of it because you will get confused with it. Right? With this, I would like to give rest to my lecture. I hope you must have understood. And as I always say, kindly keep the bare acts. Kindly, after the lecture also, revise by seeing the bare acts, by making notes and revising your notes once again so that you could relate with the other lectures that I'm going to take in future. So, till then, keep studying, keep revising, keep your books open, and take care. And thank you so much for listening.